Welcome, everybody. Welcome to an impromptu Law of Self-Defense show. I had told everybody, including our moderators, I was not doing a show today. I guess I lied because I am, in fact, doing this show right now, today, on the loss of the Titanic submarine and an interesting legal question that might have occurred to some of the more cold-hearted among you. As I must confess, it occurred almost instantly to me. And that is, if you have a bunch of people stuck in a submarine waiting for rescue with a limited air supply, would it be lawful for some of the sub-passengers to kill other sub-passengers so that the limited available oxygen would last longer and therefore increase the killer's prospect for surviving to rescue? That is the question, and whether or not, of course, you could do that and have it be lawful. And there are legal doctrines that apply to this situation. And an old English court case from the 1880s, that's kind of the seminal court decision on this question. It's the one used for, first-year law school type exams. So we're going to discuss today the legal doctrines that would arguably privilege the killing of an innocent person, not somebody attacking you, but someone who's doing nothing wrong, in order to increase your own prospects for survival. Those legal doctrines exist under American law, and I'll give you a few examples. And then also we'll look at the actual 1884 British decision that addressed very similar questions to what these poor passengers in the submarine are looking at today. So with that out of the way, let's go ahead and do the formal launch of today's show. Stand by. All right, so the question: can you kill an innocent person so you can live? And the legal doctrine one would turn to answer this question is, well, it's very old law, so it goes by different names, but the legal concept is the same throughout. So we're going to dive into that and into the British case as well. Before we do that, of course, I am obliged to mention our sponsor, which is none other than Law of Self-Defense itself. If you're not yet a Law of Self-Defense member, I have to ask you why, given how inexpensive it is. Most of the content we produce every week is for Law of Self-Defense members only. Law of Self-Defense membership, you can try it out for 2 weeks, unlimited access to thousands of our plain English legal analysis of use of force events for just 99 cents, folks. 99 cents for 2 weeks. And if you stay a member after the 2 weeks, and virtually everybody does, it's still dirt cheap. It's only about 30 cents a day, folks. 30 cents a day, less than $10 a month to be a Law of Self-Defense member. And get access, unlimited access to all our members-only content. Of course, it gets even better than that, because not only can you do that, you could bump yourself up to being a platinum member. Platinum membership gets you the only way to get access to my expert legal consult services in court. If you're ever involved in a use of force event, I don't take outside consults anymore. If you want my expertise on your legal team, you must have been a platinum member at the time you were compelled to use force in defense of yourself, your family, your property. You get that coverage for 5 years, folks. 5 years plus $3,000 of all our Law of Self-Defense educational content, every book, every course that we offer. Plus, you are the only people whose comments and questions I address during these live streams. Plus, you get transcripts of every show that we do, so you can document your specialized knowledge to ensure that it would be admissible in court in your defense. You get all that and more for 82 cents a day, folks. 82 cents a day. I know you have that in your couch. Learn more about this opportunity to be a Law of Self-Defense Platinum member for 5 years. Plus, by the way, your spouse is covered too. This also covers your spouse. No additional cost. 82 cents a day. Learn more at lawofselfdefense.com/82 cents. All right. So let's talk about the situation. We have this Titanic submarine. It's out of communication. It's running out of oxygen. Nobody knows what's happened to it. It's not been located, at least at the time of this Law of Self-Defense live stream show. But one thing we can be sure, assuming the passengers are still alive in the submarine, they have a limited supply of oxygen. They had a limited supply of oxygen the moment they sealed up the submarine. And then something went wrong. Let's pretend it was some kind of electrical failure. Shorted out. No control of the submarine anymore. It's just at the bottom, or it's floating around, or whatever. And the passengers are hoping to be saved, or alive in the sub, hoping to be saved. They know they have a limited supply of oxygen. And anyone would know that that limited supply is consumed more rapidly the more people are respiring. So if you have, let's pretend you have 10 passengers in the submarine, and that would give them, make up a number, 10 days of air. I'm sure that's not how long it is, but just for simple math. Well, if you only had 5 passengers, that would give them 20 days worth of air. What if half the passengers decided to double their oxygen supply in terms of how long it would last by killing the other half of the passengers? Even if one passenger just killed one other, that would be a 10% increase in their effective oxygen supply, assuming my made-up numbers of the number of passengers. Could that be legally permissible? Well, there is a legal doctrine that could be argued called the Doctrine of Necessity. It goes by different names. Sometimes it's the Doctrine of Lesser Evils. Sometimes it's called the Doctrine of Competing Harms. This is a very old legal doctrine, dates hundreds of years at least, certainly back into Old English common law, from which, of course, America initially derived its law. And it's law in all 50 states, this legal doctrine, usually by statute. But if it's not in statute, it's in the case law, the appellate court decisions of your state. And essentially what it holds is that if you commit an act that would normally be a crime, you can be relieved. It's excusable. You can be relieved of the normal criminal liability for that crime if it was done to avoid some greater harm. So you committed a lesser harm to avoid a greater harm. That's the doctrine of lesser harms. Or there were 2 evils at stake, and you committed the lesser evil to avoid the greater evil. That's the doctrine of lesser evils. Or otherwise, it's called the doctrine of necessity. But the legal concept is all the same. So some examples of this might be you're walking down the street, minding your own business. There's a row of parked cars. It's hot. It's Texas. It's Texas this time of year. And you walk by a car and you see there's a baby strapped into a baby seat in the car. All the windows are rolled up. That's a life-threatening circumstance for that baby. If the baby's not removed from the car, it'll die in that car. You have the reasonable belief that would be the unavoidable outcome if things are not left addressed. So you look around, you don't see anybody else. There's no owner of the car. There's no one to turn to. So you break the car. Oh, and the car's locked. So you can't just open the door. You break the car window so you can open the door, access the car, get the baby out of the car so the baby doesn't die. Breaking a car window, is that a crime? Sure, of course. That's criminal mischief. That's destruction of property. You're not just allowed to go around breaking people's car windows. So normally there would be criminal liability for that. You would avoid the criminal liability by saying, yes, I broke the window. That's normally a criminal offense, but I did it to avoid a greater harm, the death of the baby. Another example might be someone who, say they got their driving license suspended. So they're not allowed to operate a motor vehicle because they have a suspended driver's license. But suddenly their wife falls desperately ill. They don't have a phone. There's no neighbors nearby. The wife looks like she may well die if she's not brought to a hospital. And the only way to get her to the hospital would be for the husband with the suspended driver's license to drive her there. Driving the car is unlawful for him. He's committing a criminal offense, but he's committing a small harm to avoid a greater harm, the death of his wife. So you understand the concept. It's not that complicated, but there are specific conditions that have been layered on to this basic concept over the years to avoid its abuse. right? Because what is necessity? It can be highly subjective. What one person thinks is necessary and another is not. So the classic conditions imposed on this doctrine of necessity, doctrine of lesser harms, is one, that the harm to be avoided needs to be an imminent harm, something that's immediately about to occur, not some theoretical future harm. The second classic element layered upon this concept is that the harm you're concerned about was not of your own making. You did not create a circumstance necessary that you believe made it necessary for you to commit the lesser harm. And the third traditional condition layered upon the doctrine of necessity is that there was no less harmful alternative available to you than the one you chose. So an example of that would be the baby in the car scenario I described, but the doors are not locked. So instead of breaking the window, you could have simply opened the door. Then breaking the window cannot be excused under the doctrine of necessity because there was a less harmful alternative to you. Another more modern condition that's been layered onto the doctrine of necessity is really political in nature. And that involves you can't use the doctrine of necessity to justify what would otherwise be a crime based on a moral imperative. And this was layered on because of nuclear power plants and abortion. So people would protest nuclear power plants, they'd climb the fences and all this kind of stuff because they believed in their minds that nuclear power was going to melt to the core of the earth and destroy human civilization. So they would be arrested for this trespass, property destruction, whatever they were doing against a nuclear power plant, and criminally charged, and their lawyers would raise the doctrine of necessity as a legal defense. They'd say, sure, we climbed the fence, we did this stuff, but we committed that lesser harm to avoid apocalypse, the greater harm that nuclear power represents. That's not going to be permitted under the doctrine of necessity because it's not an imminent threat, and also it's a public policy dispute that you're really having. The same with abortion. So they would pass these laws saying you can't protest an abortion center within whatever distance, 100 yards, whatever it might be, and protesters would violate that prohibition, get too close to the abortion center, and get arrested. And then say, well, we're raising the doctrine of necessity because we believe abortion is a sin. It's the murder of a child. We're avoiding the greater harm of the murder of a child by protesting within the boundaries that we're not supposed to be in. And again, that just was made impermissible to apply the doctrine of necessity in that context. Again, because even if the harm were imminent, it was deemed by the courts to be a public policy argument. They were not going to allow the abortion protesters to rely on the doctrine of necessity to escape criminal liability. Now, you may agree or not agree with those legal decisions, but that's why they were imposed. So, one, the crime committed, the harm to be avoided is an imminent harm. One, it's not a result of your own actions, your own recklessness or negligence. Two, there was no less harmful option available, and it's not a public policy question. So I'm not going to deal with the public policy element with the submarine because obviously that doesn't apply here. So that would be the question. So if you're the passenger, one of the passengers on the submarine, can you kill one or more of the other passengers to extend the oxygen supply and rely on the doctrine of necessity? That you were facing an imminent threat, and even though the threat of the exhaustion of the oxygen may be hours away or days away, one definition of imminence is that something's immediately about to occur, right in the next moment. That's the predominant definition of imminence. But another arguable definition of imminence is that the danger is otherwise unavoidable. If something isn't done now, it will inevitably occur. And that would apply here. That's the definition of imminence often applied in domestic abuse, murder type cases, where the abused victim kills their husband while he's asleep. Clearly, that's not classic self-defense. He wasn't an imminent threat to her in the moment, but her argument is, well, he wasn't in the moment, but I knew when he woke up he was going to beat me because that's what he does every time he wakes up from a drunk. So it was otherwise inevitable, and that makes it an imminent threat. So that's the argument you would make here. So the harm to be avoided was imminent or otherwise unavoidable. It was not of the submarine passengers' own making, this threatened harm. You might say you get into a submarine, there might be an issue, but it wasn't their recklessness or negligence that raised the risk. And there's no less harmful alternative available. They don't have some optional or accessory source of oxygen, for example. This is it. If you're going to extend the oxygen supply, the only way to do it would be for some of the other passengers to not be breathing anymore. Would that work? Would the doctrine of necessity work to justify the one passenger killing other passengers? That's the legal question. And I will answer it for you using American law. But first, I'd like to take a look at this old English case that involved some men at sea whose ship sunk, and they found themselves adrift in a lifeboat. This was in the 1880s. So there were 4 men in the lifeboat, and 2 of the men, maybe 3, but 2 of them for sure, decided to kill one of the other men in order to improve their own chances for survival. They believed that certainly all 4 of them would die if they didn't kill one of their compatriots in the lifeboat, basically to eat him, to drink his blood in place of water that they didn't have, and to eat him for food, to cannibalize him, literally cannibalize him. So this is the case of the British court, versus Dudley and Stephens. It's termed R versus Dudley and Stephens because R, I believe, was the prosecutor in the case, and the case occurred in 1884. When was the actual sinking? I think I'll get to that. Let's see. Yeah, the same year. Interesting. All right, so I'll just go through the facts, and then we'll look at the decision. So it was a yacht, a privately owned yacht with a 4-man crew. The crew was the owner, Dudley, one of the defendants in the case. He was the captain of the ship, and he brought some friends with him. One of his friends was Stephens, another of the defendants. A third was Brooks. And the fourth was a cabin boy. The youngest, 17 years old, an inexperienced seaman. This was Richard Parker. Richard Parker would be the one killed on the lifeboat. So the yacht's sailing along. It was going around from Sydney to Sydney from Southampton. So a long voyage from Britain to Australia. And they're at sea and they're sailing away, and they were, let's see, a wave struck and washed away one of the sails. And the captain immediately realized the yacht was doomed. They were in a storm. They didn't have their sail. And he ordered the 4 men, the 4 passengers on the ship, including himself, into a lifeboat. The lifeboat was a flimsy construction, only 1/4-inch thick boards. And they put a hole in it as they lowered it to sea to try to get away. Their main vessel, the yacht, sank within 5 minutes, and the crew abandoned ship. They salvaged only some vital navigation instruments, 2 tins of turnips, and no fresh water, no water at all. And they are in the middle of nowhere. So they had to fight off a shark with oars. They were 700 miles away from the nearest land. They kept the tins of turnips uneaten until finally they just began to starve. Excuse me. They managed to catch a sea turtle. They ate that, presumably raw. They were going to drink its blood for hydration, but it had been contaminated with seawater, so that didn't work. They weren't able to catch any rainwater. And within a week of being at sea, they were beginning to drink their own urine. The men, obviously, at this point were in failing health. And they started discussing drawing lots, straws, to choose a victim that would die to feed the others. So they're debating this amongst themselves. They couldn't agree. And finally, the captain told the others it was better that one of them die so that the others survive, and that they would choose straws. Now, one of the other 3 survivors, Brooks, not a defendant in this case, refused to do this. He wasn't drawing straws to see who would live. They discussed it some more. And then the next day, the captain, Dudley, and Stephens, the 2 men who would be defendants at trial after this, signaled to each other that it would be the cabin boy, Parker, who would be killed. And that way they would be able to drink his blood for hydration and have him for food, for sustenance. And they did. Dudley said a prayer and with Stephens, the other defendant, standing by to hold the cabin boy's legs if he struggled, the captain put a knife into the cabin boy's neck, cutting his jugular vein, killing him. Well, of course, eventually the other three men were rescued, did survive, and they were charged. Dudley and Stephens, at least, were charged with murder for the killing of the cabin boy, Parker. So with those basic facts out of the way, let's look now to the actual case. Before I do that, I'm going to take a look at the law of self-defense members live stream at the chat, because we do answer questions. I see someone's asking, outside the scope of law of self-defense. Not really. It's a justification defense. You would use the doctrine of necessity in a variety of ways in a self-defense type of scenario. For the crime of the use of force against the other person, you justify that as self-defense. But what if, for example, you were traveling, you're visiting a state in which you're not permitted to possess a firearm? You're in New York, you're in New Jersey, you're in Maryland, you're in Illinois, and you don't have the required state authorization to possess a firearm. And you're going about town, enjoying the day, and you see a bank robbery taking place right before you. In fact, there's an officer standing in the street. He's gunned down by the bank robbers. As he's engaging them with his own pistol, the bank robbers just start killing everybody they see in the vicinity. It becomes an active shooter type scenario in their desperation to get away. And you pick up the downed cop's pistol to engage the bank robbers. Well, you just committed a crime. You're not lawfully permitted to be in possession of a firearm in that jurisdiction. And now you are. And you did that intentionally. You knew it was unlawful and you picked up the gun anyway. And you could be charged with unlawful possession of a firearm. And in some of these states like New York, that's a felony right there with a long prison time under the Sullivan laws of New York. What would your argument be? Your argument would be doctrine of necessity. Sure, I picked up the gun. I committed a small crime, a relatively small crime, a pretty big crime in New York State, but a smaller crime than offense to avoid the bank robbers continuing to kill innocent people in front of me, including, incidentally, myself, but also others. So you'd be arguing that the gun charge against you should be dismissed based on the doctrine of necessity. Your shooting of the bank robbers, assuming you got that far, would obviously just be self-defense and defense of others. But the doctrine of necessity would be the legal justification for coming into unlawful possession of the firearm. Because otherwise, that's what New York does, right? So we just had the gentleman, he's in the news right now in Queens, New York, was the victim of a mugging, used a revolver to defend himself from the mugging, probably a lawful use of defensive force, but he didn't have the required permits for that gun to carry it in public and the 30 other guns they found in his home. And now he's facing a life sentence worth of gun charges, which will be applied to him even if his use of defensive force is determined to be lawful. There you go. All right. So not many chats in the, let's see, did my email go out? It did, but it went out at the very last minute. I was not planning to do a show today, yet here we are. Here we are. All right, so I managed to track down the actual British court decision, which is a little tricky to find. There's a lot of people who write about this Queen versus Dudley and Stephens case because of its classic fact pattern. It's often used in law schools, for example, to illustrate the concept of the doctrine of necessity and its limitations. A little trickier to find the actual court decision, but I did find it. I had to reach out to actual legal scholars in Britain to get it, but I have it. So let me pull this up. Here it is. Make it larger so we can read it, and we'll go through the decision. Oh, maybe not the whole decision. I hadn't realized it was 16 pages. Okay, all right. Well, we'll do what we can. So here we go. The Queen versus Dudley and Stephens. And this is old. This is 1884, this decision. So it's not structured like we're used to seeing American court decisions. But we'll just have to work through that. This is what we have to work with. So the decision reads, a man who, in order to escape death from hunger, kills another for the purpose of eating his flesh is guilty of murder, although at the time of the act he is in such circumstances that he believes and has reasonable ground for believing that it affords the only chance of preserving his life. At the trial of an indictment for murder, it appeared upon a special verdict that the prisoners, Dudley and Stephens, seamen, and the deceased, a boy between 17 and 18, Parker, were cast away in a storm on the high seas and compelled to put into an open boat, that the boat was drifting on the ocean and was probably more than 1,000 miles from land, that on the 18th day, when they had 7 days without food and 5 without water, Dudley proposed to Stephen that lots should be cast who should be put to death to save the rest, and that they afterwards thought it would be better to kill the boy, that their lives should be saved. That on the 20th day, Dudley, with the assent of Stephens, killed the boy, and both Dudley and Stephens fed on his flesh for 4 days. That at the time of the act, there was no sail in sight, nor any reasonable prospect of relief, that under these circumstances there appeared to the prisoners every probability that unless they then or very soon fed upon the boy or one of themselves, they would die of starvation. Held, the finding of the court, that upon these facts, there was no proof of any such necessity that could justify the prisoners in killing the boy, and that they were guilty of murder. We have the indictment for the murder of Richard Parker on the high seas within the jurisdiction of the Admiralty Court in Britain. At the trial before Huddleston B. at the Devon and Cornwall Winter Assizes, November 7th, 1884, the jury, at the suggestion of the learned judge, found the facts of the case in a special verdict, which stated that on July 5th, 1884, the prisoners, Dudley and Stephens, with one Brooks, all able-bodied English seamen, and the deceased, also an English boy between 17 and 18, the crew of an English yacht and a registered English vessel, were cast away in a storm in the high seas, 1,600 miles from the Cape of Good Hope, and were compelled to put into an open boat belonging to said yacht, that in this boat they had no supply of water and no supply of food except 2 one-pound tins of turnips, and for 3 days they had nothing else to subsist on, that on the 4th day they caught a small turtle upon which they subsisted for a few days, and this was the only food they had up to the 20th day, when the act now in question was committed, that on the 12th day the remains of the turtle were entirely consumed, and for the next 8 days they had nothing to eat, that they had no fresh water, except such rain as they from time to time caught in their oilskin capes, that the boat was drifting on the ocean and was probably more than 1,000 miles away from land, that on the 18th day, when they had been 7 days without food and 5 without water, the prisoners spoke to Brooks as to what should be done if no succor came, and suggested that someone should be sacrificed to save the rest. But Brooks dissented, and the boy, to whom they were understood to refer, was not consulted. That on the 24th of July, the day before the act now in question, the prisoner, Dudley, proposed to Stephens and Brooks that lots should be cast, who should be put to death to save the rest, but Brooks refused to consent, and it was not put to the boy. And in point of fact, there was no drawing of lots. That on the day the prisoner spoke of their having families and suggested it would be better to kill the boy, that their lives should be saved, and Dudley proposed that if there was no vessel in sight, by the morrow morning the boy should be killed. The next day, the 25th of July, no vessel appearing, Dudley told Brooks that he had better go and have a sleep, and made signs to Stephens and Brooks that the boy had better be killed. The prisoner Stephens agreed to the act, but Brooks dissented from it, so that's why he's not a defendant in the trial. That the boy was then lying at the bottom of the boat, quite helpless and extremely weakened by famine and by drinking seawater, and unable to make any resistance, nor did he ever assent to his being killed. So that might have changed things, right? If he'd said, go ahead, kill me, I sacrifice myself. But maybe not. The prisoner Dudley offered a prayer asking forgiveness for them if either of them should be tempted to commit a rash act, and that their souls might be saved. That Dudley, with the assent of Stephens, went to the boy, telling him that his time was come, put a knife into his throat, and killed him then and there. That the 3 men fed upon the body and blood of the boy for 4 days. That on the 4th day after the act had been committed, the boat was picked up by a passing vessel, and the prisoners were rescued still alive, but in the lowest state of prostration. That they were carried to the port of Falmouth and committed for trial at Exeter. That if the men had not fed upon the body of the boy, they would probably not have survived to be so picked up and rescued, but would within the 4 days have died of famine. that the boy, being in a much weaker condition, was likely to have died before them, that at the time of the act in question there was no sail in sight, nor any reasonable prospect of relief, that under these circumstances there appeared to the prisoners every probability that unless they then fed, or very soon fed upon the boy, or one of themselves, they would die of starvation. That there was no appreciable chance of saving life except by killing someone for the others to eat. That assuming any necessity to kill anybody, there was no greater necessity for killing the boy than any of the other three men. But whether upon the whole matter by the jurors found the killing of Richard Parker by Dudley and Stephens to be felony and murder, the jurors are ignorant, and pray the advice of the court thereupon. And if upon the whole matter the court shall be of opinion that the killing of Richard Parker be felony and murder, then the jurors say that Dudley and Stephens were each guilty of felony and murder as alleged in the indictment. The learned judge then adjourned the assizes, the trial, until the 25th of November at the Royal Courts of Justice. On the application of the Crown, they were again adjourned to the 4th of December, and the case ordered to be argued before a court consisting of 5 judges. So basically here, this almost sounds actually like a grand jury proceeding rather than a trial proceeding. And the grand jury can't make up its mind. They don't know what the right answer should be here. They're asking the court to make the decision. Let's see. Some of this may just be some of this is questions of jurisdiction. The vessel was British. The men were British, registered British vessel. So, a court first has to establish that it has jurisdiction over the case. And here we're dealing with an admiralty court that might not have jurisdiction if it was not a British vessel, for example. So they're addressing all that. Then we have part of the legal defense here. A. Collins for the prisoners. The facts found on the special verdict show that the prisoners were not guilty of murder at the time when they killed Parker, but killed him under the pressure of necessity. Necessity will excuse an act which would otherwise be a crime. The law as to compulsion by necessity is further explained in other treatises, and an opinion is expressed that in the case often put by casuists of 2 drowning men on a plank large enough to support one only, ironically, the end of the movie Titanic, right? And one thrusting the other off, the survivor could not be subjected to legal punishment. In the American case of U.S. v. Holmes, I'll have to look that up. The proposition that a passenger on board a vessel may be thrown overboard to save the others is sanctioned. The law as to the inevitable necessity is fully considered. In Russell on Crimes, another legal treatise, and he cites a whole bunch of legal treatises, homicide of necessity, and several cases. Lord Bacon gives the instance of 2 shipwrecked persons clinging to the same plank, one of them thrusting the other off, and will not support both. This homicide is excusable through unavoidable necessity upon the great universal principle of self-preservation, which prompts every man to save his own life in preference to that of another, where one of them must inevitably perish. It's true that another case states distinctly that hunger is no excuse for theft, but that is on the ground that there can be no such extreme necessity in this country. In the present case, the prisoners were in circumstances where no assistance could be given. The essence of the crime of murder is intention, and here the intention of the prisoners was only to preserve their lives. Lastly, it is not shown that there was jurisdiction. The prisoners were not to try the prisoners in England. They were part of a crew of an English yacht, but for anything that appears in the special verdict, the boat may have been a foreign boat, so that they were not within the jurisdiction of the Admiralty. This objection was overcome later. Jurisdiction was established. It was a British boat. We continue. Sir H. James for the Crown. Lord Coleridge, Chief Justice. The court are of the opinion that the conviction must be affirmed. What course do you invite us to take? So it sounds like this is now in an appeals kind of process. Being asked to pronounce judgment and pass sentence. And they're deferring to a later date. Now we have the judgment here. This is the Chief Justice, Lord Coleridge. The 2 prisoners Thomas Dudley and Edwin Stephens were indicted for the murder of Richard Parker on the high seas on the 25th of July. In the present year, they were tried before my brother Huddleston at Exeter on the 6th of November under the direction of my learned brother. The jury returned a special verdict, the legal effect which has been argued before us and on which we are now to pronounce judgment. The special verdict, as after certain objections by Mr. Collins, to which the Attorney General yielded, it is finally settled before us as follows. From these facts, stated with the cold precision of a special verdict, it appears sufficiently that the prisoners were subject to terrible temptation, to suffering which might break down the bodily power of the strongest man and try the conscience of the best. Other details, yet more harrowing, facts still more loathsome and appalling, were presented to the jury and are to be found recorded. But nevertheless, this is clear, that the prisoner put to death a weak and unoffending boy upon the chance of preserving their own lives by feeding upon his flesh and blood after he was killed, and with certainty of depriving him of any possible chance of survival. The verdict finds in terms that if the men had not fed upon the body of the boy, they would probably not have survived, and that the boy, being in a much weaker condition, was likely to have died before them. They might possibly have been picked up next day by a passing ship. They might possibly not have been picked up at all. In either case, it is obvious that the killing of the boy would have been an unnecessary and profitless act. It is found by the verdict that the boy was incapable of resistance, and in fact made none. And it is not even suggested that his death was due to any violence on his part, attempted against, or even so much as feared by those who killed him. Under those circumstances, the jury say that they are ignorant whether those who killed him were guilty of murder, and have referred it to this court to determine what is the legal consequence which follows from the facts which the jury has found. Certain objections on points of form were taken by Mr. Collins before he came to argue the main points in the case. First, it was contended that the conclusion of the special verdict was not put to them. Let's see. This is just procedural stuff. I don't want to bother addressing. Lack of jurisdiction claimed. Here we go. There remains to be considered the real question in the case, whether killing under the circumstances set forth in the verdict be murder or not murder. The contention that it could be anything else was, to the minds of us all, both new and strange, and we stopped the Attorney General in his negative argument in order that we might hear what could be said in support of a proposition which appeared to us to be at once dangerous, immoral, and opposed to all legal principle and analogy. All, no doubt, that can be said has been urged before us, and we are now to consider and determine what it amounts to. First, it is said that it follows from various definitions of murder in books of authority, which definitions imply, if they do not state, the doctrine that in order to save your own life, you may lawfully take away the life of another, when that other is neither attempting nor threatening yours, nor is guilty of any illegal act whatever towards you or anyone else. Because, of course, if the other was guilty of some unlawful act, we'd be talking about the justifications of self-defense or defense of others or something else. But if these definitions be looked at, they will not be found to sustain this contention. The earliest point of date is the passage cited to us from Bracton, who lived in the reign of Henry III. It was at one time the fashion to discredit Bracton, as one of the lawyers tells us, because he was supposed to mingle too much of the canonist and civilian with the common lawyer. There is now no such feeling, but the passage upon homicide on which reliance is placed is a remarkable example of the kind of writing which may explain it. Sin and crime are spoken of as apparently equally illegal, and the crime of murder, it is expressly declared, may be committed lingua vel factor, so that a man like Hero, done to death by slanderous tongues, would, it seems, be, in the opinion of Bracton, be a person in respect of whom might be grounded a legal indictment for murder. But in the very passage as to the necessity on which reliance has been placed, it is clear that Bracton is speaking of necessity in the ordinary sense, the repelling by violence, violence justified so far as it was necessary for the object, any illegal violence used towards oneself. So really, he's talking about self-defense. If, says Bracton, the necessity be evitabilis, et evidere. Okay, I'm not going to read all the Latin here, folks. Sorry, I don't know Latin, except for the little cliche stuff we learn as lawyers, the little phrases. Words which show clearly that he is thinking of physical danger from which escape may be possible, and that the inevitable necessity of which he speaks, justifying homicide, is a necessity of the same nature. Let's see how much of this flowery language they put in here that's not actually applicable. Again, now they're distinguishing between the doctrine of necessity and self-defense here. It is, if possible, yet clear that the doctrine contended for, necessity, receives no support from the great authority of Lord Hale. It is plain that in his view, the necessity which justified homicide is that only which has always been and is now considered a justification. Quote, in all these cases of homicide by necessity, he says, as in pursuit of a felon, in killing him that assaults to rob, or comes to burn or break a home, or the like, which are in themselves no felony. Again, he says that the necessity which justifies homicide is of two kinds. The necessity which is of a private nature, the necessity which, that's one. Two, the necessity which relates to the public justice and safety. The former is that necessity which obliges a man to his own defense and safeguard. And this takes in these inquiries. Ask these questions. What may be done for the safeguard of a man's own life? And then follow three other heads not necessary to pursue. Then Lord Hale proceeds. As touching the first of these, homicide in defense of a man's own life, which is usually styled as se defende, self-defense. It is not possible to use words more clear to show that Lord Hale regarded the private necessity which justified, and alone justified, the taking the life of another for the safeguard of one's own to be what is commonly called self-defense. Let's see. But if this could be even doubtful upon Lord Hale's words, Lord Hale himself has made it clear. For in the chapter in which he deals with the exemption created by compulsion or necessity, he thus expresses himself. Quote, if a man be desperately assaulted and in peril of death and cannot otherwise escape, unless to satisfy his assailant's fury, he will kill an innocent person then present, the fear and actual force will not acquit him of the crimes and punishment of murder, if he committed the fact. For he ought rather to die himself than kill an innocent. But if he cannot otherwise save his own life, for law, the law permits him in his own defense to kill the assailant. For by the violence of the assault and the offense committed upon him by the assailant himself, the law of nature and necessity hath made him his own protector. So what they're talking about here is they're distinguishing not just self-defense from the doctrine of necessity, but self-defense from the defense of coercion. So coercion is a legal defense. You committed an unlawful act because you were compelled by a threat made to you by another person. So someone holds a gun to your head and says, steal that car. And you steal the car because you don't want to get shot dead. Normally, of course, the stealing of the car would be an unlawful act, a criminal act for which there'd be criminal liability. But if it was committed under coercion or duress, sometimes is the phrase, the legal defense of coercion or the legal defense of duress can excuse the criminal liability. But the legal doctrines of coercion and duress can never excuse liability for you killing another person. Because there's no, so someone holds a gun to your head and says, stab that person dead or I'll shoot you through the head. And you stab the person dead, you are doing it under circumstances of coercion and duress, but coercion and duress will not excuse a killing, because from a public policy perspective, you killing that other person is not a greater harm than you having been killed by the person putting you under duress. It's closely related to this lesser harms doctrine, to the doctrine of necessity. I see Legal Vices is in the chat. Legal, if you don't have this document and you'd like it, I'll email it to you. It was a little tricky for me to find, but I'm happy to share it. And Legal Vices is an expert in admiralty law, so he'll have a lot more admiralty detail. I know nothing about admiralty law. Let's see. What else? Yeah, I don't want to read every word of this. We are on page 12 now. Okay, this looks interesting. In East's Pleas of the Crown, another authoritative text, the whole chapter on homicide by necessity is taken up with an elaborate discussion of the limits within which necessity of self-defense is a justification of or excuse for homicide. There's a short section at the end, very generally and very doubtfully expressed, in which the only instance discussed is the well-known one of two shipwrecked men on a plank, able to sustain only one of them, and the conclusion is left by Sir Edward East entirely undetermined. Another example, another treatise, the whole chapter on justifiable homicide assumes that the only justifiable homicide of a private nature is the defense against force of a man's person, house, or goods. We find again that the case of the two shipwrecked men and the single plank, with the significant expression from a careful writer, quote, it is said, in italics, to be justifiable, but clearly very ambiguous support, if any. Another authority clearly considers necessity and self-defense to be convertible terms, though he prints without comment Lord Bacon's instance of the two men on one plank as a quotation from Lord Bacon, adding nothing whatever to it of his own. So not necessarily supporting that position. That the two men on the plank that can only sustain one, it would be lawful for one to shove the other off the plank to his death. Let's see, a bunch of dicta. They're looking to, dicta is the part of a court decision, folks, that's not essential to the finding, the legal finding in the case. And typically, maybe it's just being expressed to add some color or some side thoughts of the judge writing the decision. But if what's being discussed is not essential to the legal finding in the case, it's not part of the precedential value of the case, the controlling authority of the case. It's mere dicta and not precedential. So the court asks now, is there then any authority for the proposition which has been presented to us that the doctrine of necessity can support excusing a homicide? Decided cases, there are none. The case of the 7 English sailors referred to by the commentator has been discovered by a gentleman of the bar. Hard to understand where they're going with that. It is mentioned that in a medical treatise published in Amsterdam, it is altogether an authority in an English court as unsatisfactory as possible. So there, yeah, the Dutch can be weird about these kind of life and death questions. Just look at their passion for euthanasia. The American case cited by my brother Stephen from Wharton on homicide. So Wharton is still a textbook we buy in law school today, or at least was 30 years ago when I went to law school, in which it was decided correctly indeed that sailors had no right to throw passengers overboard to save themselves, but on the somewhat strange ground that the proper mode of determining who was to be sacrificed was to vote upon the subject by ballot. Oh, cold. So if it was done by ballot, it would be lawful to throw the losers off the boat to save the others. Maybe arguably because the people who would have engaged in the ballot consented to the potential of being a loser. Let's see. The observations of Lord Mansfield in another case, as striking and excellent as they are, were delivered in a political trial, where the question was whether a political necessity had arisen for deposing a governor of Madras. But they have little application to the case before us, which must be decided on very different considerations. This issue actually comes up in American law today with these police use of force Supreme Court decisions like Tennessee versus Garner that are applied in criminal contexts. They deal with when police are justified in using deadly force upon suspects, and they set forth certain criteria, but they're civil cases. All these big U.S. Supreme Court police use of force cases, they're all civil suit cases. They're not criminal cases. And I've seen more than one criminal court object to their application in the criminal context. When an officer is not merely being sued for having used force on a suspect, but is being criminally tried as a defendant on a charge of murder or manslaughter for having killed the suspect. So it is important to keep in mind the distinction between cases argued in one context, the civil context, or what they're saying here, the political context, and a criminal context. The court continues, the one real authority of former time is Lord Bacon, who in his commentary on the maxim, again, they're using Latin, sorry, lays down the law as follows. Necessity carrieth a privilege in itself. Necessity of three sorts. Necessity of conservation of life, necessity of obedience, and necessity of the act of God or of a stranger. First, of conservation of life, if a man steals to satisfy his present hunger, this is no felony nor larceny. So if he divers be in danger of drowning by the casting away of some boat or barge, and one of them get to some plank or on the boat's side to keep himself above water, and another to save his life, thrust him from it, whereby he is drowned, this is neither self-defense nor by misadventure, but justifiable. On this, it is to be observed that Lord Bacon's proposition that stealing to satisfy hunger, so that was the end of the quote from Lord Bacon. The court now comments, on this it must be observed that Lord Bacon's proposition that stealing to satisfy hunger is no larceny is hardly supported by other legal authorities and is expressly contradicted by Lord Hale. And for the proposition as to the plank or boat, it is said to be derived from the canonists. At any rate, he cites no authority for it, and it must stand upon his own. Lord Bacon was great, even as a lawyer, but it is permissible to much smaller men, relying upon principle and on the authorities of others, the equals and even the superiors of Lord Bacon as lawyers, to question the soundness of his dictum. So they're saying we don't need to rely on precedent if there's compelling counter arguments not to rely on the precedent. There are many conceivable states of things in which it might possibly be true, but if Lord Bacon meant to lay down the broad proposition that a man may save his life by killing, if necessary, an innocent and unoffending neighbor, it certainly is not the law at the present day. There remains the authority of my brother Stephen, who both in his digest and in his history of the criminal law uses language perhaps wide enough to cover this case. The language is somewhat vague in both places, but it does not in either place cover this case of necessity. And we have the best authority for saying that it was not meant to cover it. If it had been necessary, we must, with true deference, have deferred from him. But it is satisfactory to know that we have probably at least arrived at no conclusion in which if he had been a member of the court, he would have been unable to agree. Neither are we in conflict with any opinion expressed upon the subject by the learned persons who formed the commission for preparing the criminal code. They say on the subject, quote, we are certainly not prepared to suggest that necessity should in every case be a justification. We are equally unprepared to suggest that necessity should in no case be a defense. We judge it better to leave such questions to be dealt with when, if ever, they arise in practice by applying the principles of law to the circumstances of the particular case. Close quote. It would have been satisfactory to us if these eminent persons could have told us whether the received definitions of legal necessity were in their judgment correct and exhaustive, and if not, in what way they should be amended. But as it is, we have, as they say, quote, to apply the principles of law to the circumstances of this particular case, close quote. Now, except for the purpose of testing how far the conservation of a man's own life is, in all cases and under all circumstances, in absolute, unqualified, and paramount duty, we exclude from our consideration all the incidents of war. We are dealing with a case of private homicide, not one imposed upon men in the service of their sovereign and in the defense of their country. Now, it is admitted that the deliberate killing of this unoffending and unresisting boy was clearly murder, unless the killing can be justified by some well-recognized excuse admitted by the law. It is further admitted that there was in this case no such excuse, unless the killing was justified by what has been called necessity. But the temptation to the act, which existed here, was not what the law has ever called necessity, nor is this to be regretted. Though law and morality are not the same, and many things may be immoral, which are not necessarily illegal, yet the absolute divorce of law from morality would be a fatal consequence, and such divorce would follow if the temptation to murder in this case were to be held by law an absolute defense of murder. It is not so. To preserve one's life is generally speaking a duty, but it may be the plainest and the highest duty to sacrifice it. War is full of instances in which it is a man's duty not to live, but to die. The duty in case of shipwreck, of a captain to his crew, or the crew to the passengers, of soldiers to women and children, as in the noble case of the Birkenhead, these duties impose on men the moral necessity not of the preservation, but of the sacrifice of their lives for others, from which in no country, least of all it is to be hoped in England, will men ever shrink, as indeed they have not shrunk. It is not correct, therefore, to say that there is any absolute or unqualified necessity to preserve one's life. More latent, it would be a very easy and cheap display of commonplace learning to quote from Greek and Latin authors, from Horace, from Juvenal, from Cicero, from Euripides, passage after passage, in which the duty of dying for others has been laid down in glowing and emphatic language, as resulting from the principles of heathen ethics. It is enough in a Christian country to remind ourselves of the great example whom we profess to follow. This is a reference, of course, to Jesus sacrificing himself on the cross. It is not needful to point out the awful danger of admitting the principle which has been contended for. Who is to be the judge of this sort of necessity? By what measure is the comparative value of lives to be measured? Is it to be strength or intellect or what? It is plain that the principle leaves to him who is to profit by it to determine the necessity which will justify him in deliberately taking another's life to save his own. In this case, the weakest, the youngest, the most unresisting was chosen. Was it more necessary to kill him than one of the grown men? The answer must be no. And we quote here, "So spake the fiend, and with necessity the tyrant's plea excused his devilish deeds." Close quote. It is not suggested that in this particular case the deeds were devilish, but it is quite plain that such a principle, once admitted, might be made the legal cloak for unbridled passion and atrocious crime. They're talking here, of course, about the slippery slope concept, right? There is no safe path for judges to tread, but to ascertain the law to the best of their ability and to declare it according to their judgment. And if in any case the law appears to be too severe on individuals, to leave it to the sovereign to exercise that prerogative of mercy which the Constitution has instructed to the hands fittest to dispense it. So here what they're saying is, hey, we're just the judges. We just have to apply the law. If these men are to be pardoned or have their sentences reduced, that's for the queen to do. That's not for us to do. Of course, in America, we would say that was for the president to do on a federal level or the governor on a state level. Much like we have with the Daniel Perry case down in Texas, right? The U.S. Army officer who killed the BLM Antifa protester was convicted at trial, and the Texas governor was talking about pardoning him. We haven't heard much about that lately, have we? Back to this. The decision goes on. It must not be supposed that in refusing to admit temptation to be an excuse for crime, it is forgotten how terrible the temptation was, how awful the suffering, how hard in such trials to keep the judgment straight and the conduct pure. We are often compelled to set up standards we cannot reach ourselves and to lay down rules which we cannot ourselves satisfy. But a man has no right to declare temptation to be an excuse, though he might himself have yielded to it, nor allow compassion for the criminal to change or weaken in any manner the legal definition of the crime. It is therefore our duty to declare that the prisoner's act in this case was willful murder, that the facts as stated in the verdict are no legal justification of the homicide, and to say that in our unanimous opinion, the prisoners are upon this special verdict guilty of murder. The court then proceeded to pass sentence of death upon the prisoners Stephen and Dudley. Now, I should mention that in fact the Queen did have mercy upon these two men. They ended up serving I believe it was 3 months each in prison. They were not executed for this crime of murder. So that's how the doctrine of necessity was treated in the context of the killing of an innocent person under English law in 1884. How does the doctrine of necessity deal with killing under American law in our modern era? The doctrine of necessity exists. You can be excused for committing a lesser crime in order to mitigate some larger crime. That's why it's sometimes called the doctrine of lesser harms, the doctrine of competing evils. You're committing one evil to avoid a much greater evil. You're committing one harm, a smaller harm, to avoid a greater harm. It is a legal defense in every state, and it will absolutely excuse criminal liability if you meet the conditions. And again, the conditions are the traditional limitations on the doctrine of necessity, or the conditions that must be met is the harm to be avoided is an imminent harm, immediately about to occur, or you might argue otherwise unavoidable if something is not done. That could apply to the submarine case here, where there is no alternative oxygen supply. There is nothing else that can be done. You can't pop the hatch underwater. The air will run out. So it may not run out in a minute or 10 minutes or an hour, but it's otherwise unavoidable that the oxygen will run out. That's one of the conditions, that the threat is imminent, that the threatened harm or the harm to be avoided is not the result of one's own actions, meaning one's own recklessness or negligence. You did not negligently or recklessly create the need to commit the lesser harm. And that there's no less harmful alternative than the one that you committed. So in the case of the submarine, the notion that one of the passengers might kill other passengers in the submarine to, in effect, extend the supply of oxygen, so the oxygen would last longer because fewer people are respiring. Is that an imminent harm? We just discussed that. It may not be imminent in the moment, but it might be imminent in the sense of being otherwise unavoidable. Would the killing passenger be negligently or recklessly responsible for the situation they're in? Let's assume that's not the case. And is there a less harmful alternative available? Well, probably not. So does that mean the doctrine of necessity would privilege one of the passengers to kill others, to extend the oxygen supply, to improve their own chances for survival? Well, the court here in RV Dudley and Stephens came to the conclusion that the doctrine of necessity cannot excuse the killing of another innocent person for the purpose of saving your own life. And that is how the doctrine of necessity is applied in American law today. So the doctrine of necessity, the doctrine of lesser harms, cannot excuse the killing of an otherwise innocent person, because that is the ultimate harm, is the killing of another innocent person without a legal justification. You can't excuse it. Remember, the doctrine of lesser harms is that the harm you committed was a lesser harm than the one that was avoided. But there is no lesser. I mean, there's no greater harm than the killing of another person. So if the harm you committed was the killing of another innocent person, you've committed the greatest possible harm. It can have been less than whatever you were trying to avoid. Now, could you try to argue around that? Are there facts, circumstances we could imagine where that would apply? Maybe because it's the balance of life versus life, right? The offense you committed was the killing of an innocent person. What would be greater than that? Well, maybe if it was necessary to save a much larger number of lives. So say, for example, you knew that there was a booby trap in the entrance to a shopping mall. And if the booby trap was triggered, the entire mall with thousands of people in it would die. And here you see a customer of the mall approaching that booby trap door. You're at a distance. You can't shout. You're too far away. There's no way to dissuade the person from going. If they continue going, they're going to open that door to the shopping mall and thousands of people will die. Can you take your rifle from a couple hundred yards away and shoot that innocent customer to prevent him from blowing up the mall? Now, if he were going to die too in the explosion, you might argue, well, you're really not causing any harm. That wasn't going to happen anyway, right? But let's pretend he would survive. He would live. He wouldn't be blown up, but other thousands of people would be blown up. Can you argue the doctrine of necessity to say, listen, I committed a harm, arguably the greatest harm you can commit, the taking of an innocent human life, when I used my rifle to shoot that man, that innocent man, no malice in him, to prevent him from triggering the booby trap, unknowingly triggering the booby trap and killing thousands of people. But the harm I committed in killing him saved thousands of lives. I suppose you could make that argument. You better be right about the booby trap. All right, let's see if there's any comments in the chat now. Let's see. Tony says, Andrew, can you explain how the Fourth Amendment applies to the use of force as taught to law enforcement? Maybe, Tony, but not in today's show. That sounds like a law school seminar right there. But I'll make a note of it and take a look. All right, folks, I think that's all I'm going to cover for all of you today. If you are a Law of Self-Defense member, by the way, of course, we are sponsored by the Law of Self-Defense. None other than, where is my little... Oh, come on. Here we go. Today's show was sponsored by the Law of Self-Defense. Most of the content we produce every week is members only. And you can be a Law of Self-Defense member. Try it out for 2 weeks for just 99 cents, folks. 99 cents, unlimited access to thousands of our plain English use of force legal analysis of events in the news, trials, and so forth. And if you stay a member after 2 weeks, and virtually everyone does, it's still dirt cheap. It's less, well, it's about 30 cents a day. It's less than $10 a month, folks, to be a Law of Self-Defense member. Try it out for 2 weeks at lawofselfdefense.com/trial. And if you are a Law of Self-Defense member, in the members only blog, you will get a transcript of today's show in which I will link this British court decision. So you can read it at your convenience. All right, folks, I think that's all I have for everyone today. So, as always, thank you so much for your time. It's greatly appreciated. And for all you members, your ongoing support. And until we meet again, I remain... Oh, don't forget, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. So my family is hard to kill. You also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until we meet again, I remain attorney Andrew Branker for Law of Self-Defense. Stay safe.